I'm Scotty Van Hock, capital S C O T T Y, capital V A N H A W K, the living man.
Thank you. The defendant is here in person and pro se. The state, and that is here, prosecutor Brad Bowles. We're here for the jury trial as scheduled by the court on September 17, 2024. Is the state prepared to proceed? No. And the defendant prepared to proceed? Are you ready to go, Mr. Van Hock?
No, Your Honor. I've contacted counter reporting for the dates that I was given for November the 19th and made preparations to have live active transcription here on November 19th. The order for this hearing date was just received 3 days after the deadline for filing motions. I see that you had the Sheriff Smith deliver them. The deliver that I found was on the 27th of September.
Correct.
And in that order, there was a deadline of the 24th to file motions.
And you did not contact the court prior to today to inform the court of this information.
How would I contact?
Despite my previous order for you to have Connor or whoever you want to contact me immediately after the hearing we held. Also, at the hearing, you vigorously objected to a court date, which I believe we discussed December. And immediately after the hearing, a date, today's date, tomorrow, became available, and at your request, I moved the trial to today. You got notice of this request via the electronic filing system at the latest on September 18. The order was emailed to your email that day, the 18th. The sheriff served you, as you indicated, because I had some concern that this issue might arise. And you have taken no action to contact the court at any point until just before these proceedings commence.
Your Honor, you haven't entered me in the e-file system that I've requested. The service that was attempted was not sufficient. And I would have absolutely contacted the court if I thought that I could contact you in any certain way. If I had the e-file system, I could contact you. There's no instructions or no protocol on how I'm to address the court unless I'm sitting here in front of you.
You filed no motion, which you are very good at filing motions, and you did not do that. You know that. Also, my court reporter indicates that you're incorrect when you represent you did not get it. Also, as your own attorney, you have an absolute obligation to stay apprised as to the status of your case. You failed to do so.
If I was simply in the e-file system the way every other attorney is, then I would be able to do that, but you've denied that access to me.
That is not true. So, are you making a motion to continue the trial?
No, Your Honor, I'm not making a motion to continue. I'm making, if you told me I couldn't make any motions, or I would have made a motion to continue. If you'd like me to file another motion right now, I'll write one requesting the ADA compliance.
I've ruled on that motion denied. Since you're not asking to continue the trial, we will proceed with the accommodations made before today's date.
Which again, I'll iterate, is not accurate and not sufficient.
And once again, and for the last time, I will remind you that once the court makes a ruling, it is final. We do not go over it again and again.
but the ADA violations continue over and over and over. The hearing test is not sufficient over and over and over.
Judge, we're prepared for the jury to come in.
Yes, so we will address then the issues before the court here today. We will bring the jury in once they have been introduced to the case and their responsibilities in the bailiff's introduction, as we did the last time. In front of you, Mr. Van Hock, are the jury questionnaires. I remind you that the information in those questionnaires is confidential, and you are not to disclose that information in any form or fashion outside of this courtroom. Do you understand that? Do you understand my question, Mr. Van Hock? The jury questionnaires are confidential. You understand that?
I comprehend that the information on the jury questionnaires are confidential.
Thank you. So when the jury comes in, I will introduce them to the case, go over with them how the trial will proceed as we did last time.
Your Honor, I don't have a witness list, and of course you know I don't have the file sitting right here for Mr. Bowles.
What file?
I don't have the discovery, and I don't have a witness list.
We have already gone over that. Your attorneys have verified that you do have the discovery. You were given a list of the witnesses at the last trial. Nothing has changed. And again, as your own attorney, you have the obligation to be apprised of the information on the electronic filing system. So, we will proceed.
The electronic filing system is not of access to me because you have not granted that permission. And once again, as my own attorney, I'm requesting the complete discovery file.
Not true, ruled on, we will proceed. So when the jury comes in, and again, this, you have not filed a witness or exhibit list. So this reminds me of an issue that came up last time. When it is time for you, Mr. Van Hock, to disclose to the potential jurors your witnesses, you will do so. Or, if you attempt to call any witness who has not been brought before the voir dire, so that we have made sure they don't know them or have personal knowledge of the case, they will not be allowed to testify. Do you understand that?
Your Honor, if I may.
Yes or no, sir? Do you understand that you cannot call a witness who has not been brought before the jury in voir dire? Voir dire.
Judge, we agreed last time.
Pre-selection, correct.
Your Honor, please read the transcription. That makes absolutely no sense.
Actually, it makes good sense. All right, you do understand that. Any other issues that the state would like to bring before the court here before we get started?
No, sir.
All right, so anything, well, let's go at it like this, Mr. Van Hock. We're we're having trouble remembering that once the court rules on an issue, it is ruled on for the remainder of the trial. I want you to keep that in mind. You may participate or not participate in the trial as much as you wish. However, if you fail to participate, you may waive your rights to do so, because if you don't ask a question or question witnesses, you may lose that chance for good.
I reserve all my rights, Your Honor, including my right to counsel, including my right to a common law jury, what is afforded by me by an Article III judge that's not an administrative court.
Fair enough. Remember, only one person speaks at a time throughout these proceedings. And I expect everybody to conduct themselves in a respectful manner, comply with courtroom procedures, etiquette rules. You fail to do so, you can be removed from the courtroom, Mr. Van Hoff, if we engage in disruptive activities. Do you understand that?
Are you?
Do you understand that, Mr. Van Hoff? You must act civilly in this courtroom, comply with etiquette rules, comply with the rules of courtroom procedure, and comply with the trial rules. You understand that?
Rules for thee, but not for me. Is that what that means?
Judge,
You understand that, Mr. Van Hoff?
No, Your Honor, I don't.
What don't you understand?
I'm not sure what the last two paragraphs are for. Behavior?
I'm just warning you that you have to behave properly in front of the jury.
So you're threatening me with removing me from the courtroom?
Not so long as you behave in a proper fashion. So, we understand. All right, we'll see then. Give the jury round when we come in for voir dire. You will have the strikes in front of you. You strike for cause. You must write out the cause on your sheet. You strike for preemptories. Those will be brought forward to me. I will review them, and then I will return them to you so that you can see what the other side has done, and then I will rule on the strikes. Any questions from the stage?
no, sir.
Any questions, Mr. Van Hoff? Being no questions, we will take a recess until the jurors have had their orientation and they are brought into the courtroom.